Florida family law and parental responsibility litigation after the divorce. Hello, my name is John P.L.C. I'm an attorney with the P.L.C law firm in West Palm Beach, Florida. Our law firm is a probate litigation law firm that handles trials and disputes and appeals throughout Florida on matters involving wills, trusts, estates, probates, guardianships, as well as commercial and business litigation and related issues of homestead, real estate, investment accounts, bank accounts, and life insurance contracts. Today is Thursday, May 12, 2016, and I'm going to be speaking to you today about a family law litigation matter in an appellate opinion that was just handed down yesterday, Wednesday, May 11th, 2016, by Florida's 4th District Court of Appeal. The 4th District Court of Appeal in Florida handles divorce, family law appeals, guardianship, wills, trust, estate appeals for Fort Lauderdale, Palm Beach, and Stewart, right? Martin County, Palm Beach County, and Broward County. This decision yesterday in the Steinman case, S-T-E-I-N-M-A-M, 4D154016. You can get a PDF of this appellate opinion for free by going to the 4th District Court of Appeal website, clicking on opinions, scrolling down to yesterday's date, and then clicking on the case name, and you'll be able to read the entire appellate opinion on this Florida family law matter. Now, the Steinmans were divorced, right? And they were divorced in 2011. This appeal is from 2015. They had 2 minor children, and according to a marital settlement agreement, the agreement provided that shared parental responsibility would occur between both parents. Both parents had shared parental responsibility. The parties to the divorce also agreed in the marital settlement agreement that major decisions regarding the welfare of the children, including religious upbringing, would be made jointly whenever possible. Well, you can understand or probably guess what happened. One of the parents changed the religion or the religious upbringing of one or more of the minor children. The other spouse filed a motion for contempt, saying, hey, you violated the marital settlement agreement. We have shared parental responsibility. We're supposed to be doing things together. You unilaterally changed the religion of your child. Now, our probate litigation law firm in West Palm Beach often does work with Florida divorce attorneys. Why? Because many times there's a probate or estate or a guardianship issue that's involved in Florida divorces, and so we're exposed to a number of divorce issues. In fact, I wrote an article about the worlds colliding, where the divorce law and the estate or the probate law, those worlds collide and when they can overlap. So, in this particular case, the trial court judge, right, the family court judge in Florida, issued an order of contempt. The court found the mother in contempt for unilaterally changing the religion of the minor children. So the question becomes, in the state of Florida, when parents have joint responsibility, have joint parental responsibility, and the marital settlement agreement says that the parties would work together on major decisions regarding the welfare of the children, including religious upbringing, that would be done jointly whenever possible. Can one parent unilaterally change the religion of one child? Or are you in violation of the marital settlement agreement? And remember, Florida divorce attorneys and Florida family law lawyers will tell you that most marital settlement agreements from a divorce are accepted or approved or made part of a final judgment or an order. So if you violate the marital settlement agreement, you can be in contempt of court. Now, evidently the law in Florida is if you change the religion of one of your children unilaterally, for you to be in contempt of court, you have to demonstrate that there was actual harm to the child. So the 4th District Court of Appeal in this family law opinion or this divorce opinion or in this parental responsibility appeal said, we've recognized that a trial court cannot preclude the custodial parent of one religious faith from actively influencing the training of the child inconsistently with the different religious faith of the other parent, and require the custodial parent to raise the child in the other parent's faith and cooperate with the other parent in effecting the result. Allowing a court to choose one parent's religious beliefs and practices over another's in the absence of a clear showing of harm to the child would violate the First Amendment. So you can understand that parties to a divorce may have a difference of religious beliefs, and they may have very strong feelings on how their children are going to be brought up. And so one parent may want one religion or one form of one religion, and the other may want a completely different one. In Florida, to change a minor child's religion, you have to demonstrate harm for there to be some type of contempt order if you believe one spouse violated a marital settlement agreement or some other judgment or order from the divorce court. My name is John P.L.C. This concludes my remarks on Florida divorce law and a recent family law appeals court opinion from the 4th District Court of Appeal.